So, good morning, everyone. My name is Advocate Kunal Gokhale, and I will basically be dealing with different forms of debt recovery, which are available in India. And basically, I mean, even I was surprised. There are basically 7 different acts. Just as an introduction, I would like to tell you that basically debt recovery is possible under 7 different acts, and depending on the nature of the debtor, nature of the creditor, what sort of relief you are looking for, based on that it is possible to decide which forum will be the most appropriate forum. So that was the idea behind this session, is to basically just give you an idea as to how each and every forum, what the forums are, what the salient features are, and just give you an overview of the procedure that is followed before them. And at the end we will also see practically, if we have a certain type of a client, then which is the most appropriate forum for him, and what are the factors to be kept in mind while choosing a specific forum. So with that, I'll start with our discussion. Now, first of all, I'll just deal with although our topic for today is, different forums, which is more on the procedural aspect. But today, I would first like to begin with the aspect of debt recovery and what is the law under which, this debt recovery is being done from a substantive perspective. So basically, all of you would be aware of the Indian Contract Act. So basically, these debt recovery matters arise from the Indian Contract Act. And you can have different types of contract through which a debt arises. So it is not a case of only a bank giving a loan where a debt arises. You may have cases, in fact very common are cases where there is a service provider or a trader or a manufacturer who has sold certain goods to a person, and although he has supplied these goods, he has not received any payment. So basically there is a contract for sale of goods, and the consideration for the same will be that the buyer of those goods will be making a payment for the purchase. So this is the agreement between the parties, and when such a payment is not made by that person, by the buyer in this case, then that constitutes a breach of a contract. And on breach of a contract, you are entitled to basically damages, which in this case will be the amount that is already decided, like the consideration that was already decided between the parties. Now, other than sale of goods or providing services or loan agreement, some other forms would be a form of advance payment. Now, sometimes you may make a payment on an advance basis to show your goodwill, that sometimes actually it is the supplier who may make an advance payment, where he basically conveys to the buyer that I will honor our agreement, everything will be done properly. So it is like a guarantee which is given by the supplier himself. And if the buyer in such a case fails to give that money back, then that too would be a form of debt recovery. Another form would be, in my view, and this is a matter which we have also dealt with, is when loan rent agreements are entered into, then a security deposit is usually kept by the tenant or the licensee with the landlord or the licensor. So now it may happen that the landlord at the end of the period is maybe unhappy with how the specific property was maintained, and for that he refuses to give back the security deposit. Now such a case would also be in a form of a debt recovery, because there is my money as a tenant, the tenant's money or the licensee's money is with the landlord, and that is to be received back by him. So you have, even debt, you have to understand, can take different forms. And but again, the principal law in this case will be the Contract Act, and that is the root or the source for any relief that can be claimed by the creditor. Again, when it comes to debt, there are 2 or 3 types that we should keep in mind. First is that, of course, the principal amount. So if a bank has given the loan, that loan amount would be recovered. Or if there is a sale of goods, then that basically the consideration amount would be the principal amount that should be recovered. Then you also have the concept of interest. Now basically the whole idea behind interest is that over a period of time, the value, on account of inflation, the value of that consideration goes down. So suppose if I give a loan of 1 crore today, and if I am to receive the same 1 crore after 5 years, on account of inflation, that value of that 1 crore is not the same as it was 5 years ago. So on account of that, we also have the concept of interest, where we say that the time value of money remains the same when I receive the principal amount along with interest. So again, there we should be mindful of the fact whether interest is forming a part of my contract itself, or is there any specific law which provides that in case there is any delay in payment, interest has to be paid, come what may. Interest has to be paid to the supplier. So these are also things which have to be kept in mind. If a contract does not specifically talk of interest on delayed payment, then in such a case, can interest still be charged? Do the courts have the power to charge interest? So these are also aspects of debt recovery that we should keep in mind. Another point is, that we have the concept of guarantors. So basically, under contract law, when a person says that, in case the debtor is unable to pay the creditor, I will step in and pay off the dues of the debtor to the creditor. Now, such a person is known as a guarantor. And in case of a guarantor, again, we will approach it will if the guarantor. So suppose now the debtor is unable to pay the creditor, and then there is a guarantee agreement in place. So the creditor will now approach the guarantor saying that since the debtor is unable to pay, you pay the amounts to me. And now if the guarantor refuses to pay off the said amounts to the creditor, then in such a case, again, the fora will be, debt recovery. It will again fall within the scope of debt recovery. So these are a few, important things to be kept in mind from a substantive perspective. And this is important to be kept in mind at both points of time. First, when you are, even drafting the agreement. Now, suppose you're drafting the agreement, keep in mind that there should be some provision of interest. Then, even when it comes to interest, it should not be exorbitant. So you cannot say that, I'll charge maybe 30% interest per annum if there is a delay in payment. That is too high. So it has to be as per commercial norms. So if banks, generally the courts will look at, what the rate the banks are charging for loans. So it has to be as per commercial norms. It should not be too excessive. So these are a few things which should be kept in mind. This is important at the time of drafting the agreement, and also at the time of choosing which forum will be the ideal forum to go for. So I'll also deal with, what are the basic documents that you need for debt recovery. Now, why I'm telling this is that in, practically what I've seen, we also have a few MSME clients. So the big clients will mostly have all the documentation in place. It is usually the MSME clients who say, we don't have enough manpower who's going to look at the documentation. So the different steps. So basically, when, as I said, that, all the debt recovery matters flow from contract. So as we know, any contract is an agreement between two parties where there is an offer and a proposal, right? So, and then there is acceptance of that offer. So in this case, usually what happens is that, there will be a proposal given. So I'm talking at more from the perspective of trade transactions, that usually one party will give an offer, which is also known as, like an RFQ and all. So basically in that offer, they will give the details of, on what basis will supply be done. If that is acceptable to the buyer, then he will issue a purchase order. And basically when this after this purchase order is issued, after that those goods will be supplied. Now when the goods are supplied, along with that, usually we also have what is known as a delivery note, and this delivery note is basically sent along with the courier company or the truck driver who is going to be transporting the goods. And usually this receipt can also be acknowledged by the buyer. So that again becomes an important document to show that yes, these goods have actually been received by the buyer. So tomorrow the buyer cannot say that, okay, there was an agreement for me to purchase the goods, but I never received the goods. Another important point is one should always see whether there is any objection or dispute raised by the buyer. So the buyer may say that, with respect to certain type of plastic, I was supposed to receive plastic of a certain grade, but what you have given me is something completely different. So this constitutes an objection. And whether it is resolved or no, that is something that needs to be seen, because otherwise the buyer may file a case against you. Instead of saying that the buyer had agreeing to pay you something, he may say that because you did not give me the right raw material, now I have to, I have suffered damages. I was not able to supply goods to my customers, and accordingly I will now claim damages from you. So this is again an important aspect. And why this is important is also, as I will explain later, that if this becomes a dispute, then a forum like NCLT, which also deals with, which in a way deals with debt recovery matters, would not be taking up the issue. So whether the transaction is disputed or no, again becomes important, because only once the goods have been supplied and accepted by the buyer can you say that now you are the buyer is liable to pay you, right? So from that perspective, it's important to remember even this aspect of disputes. Thereafter, once the goods are accepted, invoices are raised, and then if payment is not made in time, usually the invoices will mention as to how much time period, how much credit period is provided. Usually it's 30 days from date of delivery or 45 days. Now, if this payment is not made within that time, then the supplier or the creditor should ideally send reminders for payment of dues, and so that it is all documented. Basically, it is on paper that you have been following up with the buyer or the debtor for payment of dues. And another important point is we should also always check whether there has been an acknowledgement of the debt. So sometimes what may happen that practically the debtor may say that, okay, I understand, I acknowledge that I have to pay you this XYZ amount, but currently I'm in a bit of I'm having a bit of a financial issue. I am unable to pay you, but I will pay you in some time. Just give me some more time. So here, instead of disputing the debt, instead of saying I don't owe you anything, the debtor is actually acknowledging the debt. So this will definitely help in a court of law, where we show that, see, the debtor is actually. So what happens sometimes is that sometimes initially the debtor acknowledges the debt, says that just give me some more time, and when he sees that you have approached the court, at that time for the first time he will start raising disputes, that whatever goods you gave to me were not right, what I had asked for was something different. So accordingly, this acknowledgement of debt is a very helpful document to have. Another important point is that it also helps to extend the period of limitation. Now, as you know that sometimes clients may come to you saying that it is we had raised an invoice in suppose 2016 or 17, and we have not been paid. Now it's been 5 years since 2016 passed, right? Now whether in such a case, whether the buyer, whether the creditor is still able to recover the debt. Now we have the period concept of limitation period, which basically says that you have a period of 3 years. So once the debt arises, within 3 years, you have to approach the court. Otherwise, you have slept over your rights. And now, basically, you have not been cognizant and alert about pursuing your remedies. So now the court cannot help you. So here, once there is an acknowledgement of debt, a fresh period of 3 years begins. So suppose 2016, the invoice was raised. Nothing was done for 5 years. In 2022, for the first time, you asked the buyer or the debtor to pay off your dues, and the buyer now says that yes, I acknowledge that I have to pay you. Just give me some more time. It is an acknowledgement of debt, and again you will get a fresh period of 3 years. So now, from considering it's August 22, even for an invoice pertaining to 2016, you would be able to approach the courts up to a period of maybe August 2025. So this again is an important, thing to be kept in mind, that an acknowledgement of debt helps to extend the limitation period. Another important point you should always ask your client is also, the ledger account of the debtor in the books of the client or the creditor. So here again, you will get to know the exact amount which is due from the debtor. And so basically, another important point to see in some statutes, the sending of a notice is mandatory. So, as I said, IBC, which is your Insolvency Bankruptcy Code, where you approach the NCLT, if you are a trade debtor, that is, there has been a sale of goods or services, and liability has arisen, the recipient has not made the payment of consideration, then in such a case, it is mandatory to first send a notice. Similarly, in arbitration also, it's mandatory to send a notice saying that, a dispute has arisen. So, but as a good practice, it may be useful to send a legal demand notice prior to initiation of litigation. Now, why I say this is because, sometimes it may happen that the client comes to you saying that this person is just not responding to my calls or emails. What should I be doing? Now, in such a case, for the last, 1 year, he's not been responding to me. But if the debtor receives a legal notice, then, practically we have seen that sometimes they do take cognizance of the fact that, okay, perhaps the creditor is serious about this recovery recovery, and now he's engaged a lawyer. So instead of the matter going to litigation and me having to go to court, let me settle down now. But that again is depends on the debtor, and how much he is willing to prolong this entire repayment, because finally if he is not disputed, he has to pay. But we see some debtors who know that even if they go to court, at the very end of the fag end of the legal proceedings, they'll just offer to pay off the principal amount. They would have earned interest for a good period of 6-7 years, and then they'll say, okay, let's settle the matter and I'll pay off your principal amount, let the interest be. So there again, it becomes a bit of a commercial call, depends on how much risk the debt also has. But as a good practice, it will be good to have a legal notice also sent up, although it may not be statutorily mandated. And like I said, that will be good to have all these documents in place. Now, of course, if your client is a bank, like I'm talking from the perspective of a creditor client. So if your client is a bank which can go under IBC or under the DRT route, then or even civil court, then in such a case they would generally have all the documentation in place. But what we see is that usually it's the MSME clients who also have now become very active with respect to recovery of debt. The key point being that these are very small clients, they do not have enough liquidity, so they cannot wait for 2-3 years for their dues to be cleared off. And from that perspective, MSMEs have now started playing a very important part also, or MSME debt recovery has also become like a very big forum now. And from that perspective, it will be important, like I said, that any agreement that is there, it is always important to have documentation. So all these documents, when you are speaking to a client, you can try and ensure that these are in place, try and ensure that these processes are in place, so that at the time when the dues arise, the client shouldn't come to you and say that, oh, there is no purchase order on the delivery note, we don't have any acknowledgement. So this will only going to help to strengthen the case of the client with proper documentation. So this, I just wanted to deal with, what are the basics, basic law substantively when it comes to debt recovery, and what are the basic documents you should have in place. This is more from a trade, like I said, that because most clients will usually be trade creditors or operational creditors. That is why I am also referring to these documents. Otherwise, you would always have some agreement in place, whether it's for a security deposit or whether it's for a loan as well. So now, as I said, there are 7 different forums for recovery of debt. These are, I'll just take you through and then we'll discuss in detail what the salient features are. So first is civil courts. This is your regular district courts where you can file a suit. Then government had in 2016 come up with the the Commercial Courts Act, which basically designates certain courts as commercial courts. These are actually civil courts only, which are designated as commercial courts. Mostly CPC is followed. However, there are a few tweaks that are made to CPC to basically ensure the ease of doing business. So basically, the government wants to ensure that India goes up in the ease of doing business rankings, which are given out globally. So from that perspective, these commercial courts have been brought in, and these are meant for different commercial matters, but they are also useful for debt recovery. Then we also have Micro Small Enterprises Facilitation Council. This is meant for entities which are registered under your MSME Act. Again, we also have, so basically, just to tell you, the first two, that is the civil courts, commercial courts, are the actual courts. In case of Micro Small Facilitation Council, it is more like an arbitration mechanism. In case of a National Company Law Tribunal, as the name says, it is a tribunal. Tribunals are a little different from the courts in that, with respect to CPC procedure or evidence, those rules do not strictly apply to a tribunal unless it is specifically mentioned in the Act. So with respect to procedure, the tribunal can decide its own procedure, and it is perhaps not as stringent as the procedure before the civil courts. Then we also have arbitration mechanism, where if the parties decide amongst themselves that they want, if any dispute arises or there is a delay in payment and they would themselves want to resolve the dispute by appointing an arbitrator, then even arbitration mechanism is available. We also have debt recovery tribunals. Debt recovery tribunals are mainly meant for recovery by banks and financial institutions. So these are dedicated tribunals meant for where the creditors are the banks or financial institutions mostly. Now, like I said, that there are 7 to 8 different laws that we are dealing with here, and it is not possible to do a deep dive in every each and every forum. So I will basically be giving you an idea. The idea is to just give you a flavor of what debt recovery forums are available. And one that I also got to know recently is also Cooperative Court. So this is mainly for, we have the Maharashtra Cooperative Societies Act 1960, where you also have cooperative courts. Now, although it is known as a cooperative court, it is still a tribunal. And also you have a separate entity which is known as the Registrar for Cooperative Societies. So in both these cases, there is a forum for recovery of money. However, this is again limited to a cooperative society. So just as we have, various cooperative banks, like in Pune, we have, for example, Cosmos Bank. So such a bank would be able to approach the cooperative court or even housing society. So another example of debt, as I said, that housing societies, many times it may happen that members are not paying their dues on time, which is why the housing society is not able to function properly, right? So in such a case, also they have the option, instead of having to go to civil court to recover their dues, there is a dedicated forum even for housing societies to approach the registrar and recover their debts in a fast track manner. So these are a few forums. I'll just come to them. We'll discuss them properly. Right? Now, civil courts. We can say any kind of matter when it comes to debt recovery can be taken to civil court. So in our case, for example, we have filed matters where an advance was paid by the client as a guarantee that he will supply the goods and the goods will be of a certain standard, but the project didn't go through and advance was not repaid. So that kind of a debt recovery can be filed before civil court. In one case, the security deposit has not been returned to the tenant. That's why we have gone to civil court. Another matter is your regular debt, where the client has supplied the goods, not received any. And even sometimes, banks, if it is a matter where, so basically for DRT, like I said, banks can approach, but there the threshold limit for the loan amount is 20 lakhs, like principal amount plus interest. So in such a case, if the threshold is less than 20, then even banks may be coming to civil courts. Or even an MSME, if it doesn't wish to go to, MSME is a micro small enterprise. So if it doesn't wish to go to your MSME council, even that can come to civil court. So like I said, there are not many thresholds or limitations with respect to either the nature of the dispute or with respect to the type of the debtor or creditor. So suppose, like I said, that you can go to NCLT under your IBC code only if the debtor is a company, right? For others, you cannot go to NCLT. So if the debtor is a partnership firm, NCLT route is not available to you. So in such a case, with civil court, that your matter will be entertained. And I will just quickly take you through what the stages are, so that it's possible to understand how civil courts will function and what is the procedure, and why as an alternative we have so many other forums. So basically, first we will file a plaint where we will give details of the debt and all the supporting documents are given. So here, basically, when it comes to the civil court, specifically to support your claim, you will actually need to have all the documents that have been mentioned. Basically, with respect to the agreement, what follow-ups have been done, what has been the reply of the debtor, all those things should be ideally be given along with the claim, because these are your supporting documents which help to prove that there is a debt due to you. And then a summons is issued to the debtor. Based on this summons, there is a written statement so the debtor will appear and he will file a written statement. This written statement is to be filed within a period of 90 days of receipt of the summons by the debtor. And this period, if the debtor can show that he was unable to file within 90 days, but he has a good enough reason as to why he was unable to file, then that can be extended by the court as well. So this is where the issue arises, that usually debtors may misuse this provision. They may not file a written statement, that is their reply, for a long time, and then come up with a flimsy reason. Courts may feel that instead, because if the written statement is not filed, the argument of the debtor doesn't come on record. So courts may feel that, okay, let us impose some small, some cost on the debtor, but in the interest of justice, let us allow the debtor to at least file his written statement so that we know whether he's disputing the transaction or not. So on that basis, the courts will extend. Practically it is seen that courts do extend the time period. So here is where, time limit gets extended. So basically the delays in a way start happening. And there are again, after that, so basically once a written statement is filed, then we come to the evidence filing stage, where you have witnesses and you will also submit documents. Now these documents have to be submitted. Whether to accept these documents or no as evidence has to be done as per the provisions of the Evidence Act. Now, Evidence Act again, requires that you have to give original documents. If it is a Xerox copy of a document that you're giving in the court, then you have to say as to why the original is not being given. Even sometimes courts may insist that the person who has signed the document, only he should be coming to the court. So suppose someone has signed the agreement, only the person signing the agreement should be coming to court as a witness and attesting that the loan agreement has been signed by him. So here again, it may take some time. There will be a chief, that is, the witnesses will be examined by their own party. Then there will be a cross-examination, and all this is to be done as per the provisions of the Evidence Act, which again becomes an added procedure, right? So here again, it is seen that because of these things, there is again some sort of a delay when it comes to deciding civil suits. And after the evidence stage is over, then you come to the arguments, which can be in oral form or written form. And then the court, based on the evidences, based on the plaint or the petition filed, the written statement, what evidences have been given in support of your plaint, and what arguments are finally made with respect to these two documents, that is the plaint and the evidence, will decide pass the order that whether actually debt is payable by the debtor or not. And once this order is passed, again here the interest amount which can be given is as per the discretion of the court. So now suppose the contract document, now in a loan agreement filed by a bank, of course interest will always be mentioned, but whether in case the document doesn't specifically talk about interest, then in such a case whether interest is to be awarded or no is up to the discretion of the court. So this comes from CPC as well as from Contract Act. But when that aspect of discretion of the court arises, then it is up to the court as to at what rate of interest it would like to award the interest. So based on this, the order is passed. And after this, suppose the debtor is, not willing to make payment of the debt, even despite the order, then again, you have to approach the court. These are known as execution proceedings under Order 21. And again, those execution proceedings, again, you'll have to show all the documents again and all. So there again, there is a bit of a delay. So now, because of this entire process, it was probably felt by the legislature that now the time has come to have some sort of fast track mechanism, right? So with that, we have Order 37 in the CPC, which is known as a summary suit. Now, this summary suit is like a fast track procedure. It also applies to recovery of debt in money when it arises from a written contract. And the purpose is to ensure that there is no sham defense raised by the debtor, who will in this case be the defendant, so as to prolong the litigation. Now, suppose I had gone to a regular, I had approached the civil court in a regular suit. The debtor would have had the chance to file his written statement. He would prolong that. Then when it came to evidences, he would prolong the evidence filing. He would take time to get the cross-examination done. And even if, it is a straightforward matter where the debtor has also acknowledged that he has to pay earlier. But at the time of the filing the suit, he chooses to, contest the same. Then the debtor is going to have a lot of avenues to prolong or delay the matter. And debt recovery delay is going to be harmful to the creditor because it's going to affect his working capital, his finances, right? So from that perspective, to ensure that, the defendant or the debtor in this case is not able to raise any sham defense to prolong the litigation, this summary suit procedure has been implemented. So I'll quickly take you to the procedure. First, there will be an institution of suit, as I mentioned earlier, like this is similar to civil courts, and then the summons is served. Now here is where the differences start arising between regular suit and summary suit, that once the summons are served, within 10 days, the defendant has to appear before the court. Once he has given his appearance, a judgment summons is issued by the plaintiff or the court to the defendant here being the debtor. Now, on receiving the judgment summons, the debtor has to file a document or an application which is known as leave to defend. And these leave to defend is basically a document which says where the debtor has to show that, where the debtor is now basically requesting the court that I see, I have a triable case or I have a plausible defense, and which is why you should kindly give me, allow me or sanction me to file my written statement. So basically, because this is a summary suit, there is a specific leave to defend that is required to be filed by the debtor. He does not, as a matter of right, he cannot file a written statement. He has to get that permission from the court, and he has to show that there is a substantial issue and he has a good enough defense. And so he has to request the court to allow him to file the written statement. Right now, suppose in this case, if the court feels that no, he does not have any defense, in any case, in the past he has accepted the goods and also agreed to make the payment and ask for more time to make the payment, then the court may feel that no, he does not have any defense, and in such a case, it may not grant him leave to defend. So basically, when the moment he loses the chance to defend himself in the court, then the creditor will become entitled to judgment. So directly an order would be passed, and so this will help to fast track the process, right? Because instead of having to go through all the entire procedure that I mentioned in a regular suit, this process gets fast tracked. However, it is important to remember that leave to defend, may not be granted very easily. And if the court feels that no, the debtor, although he may have acknowledged the outstanding dues in the past, but he seems to have shown that, perhaps there was some issue with the supply of goods to him, or even with respect to loan by a bank, maybe the installments were not given on time, something like that. So if the court feels that no, there is some sort of a dispute which is raised by him and it's not completely sham, then the court will allow him leave to defend. And once this leave to defend is granted to the debtor, then it again becomes an ordinary suit. And like I mentioned in our earlier slide, you will have to go through the entire process. So this is with respect to the civil courts. Now, coming to commercial courts, as I said, this act was brought in 2015. The purpose was to speed up litigation. So now there are a few procedural changes that are made. I'll just deal with the significant ones. So first of all, it has to be a commercial transaction, or there has to be a commercial dispute for a party to be able to approach the commercial court. And those types of commercial, it's defined in section 2 clause C of the act, and they've given a list of what sort of disputes are there. So like I said that suppose a housing society has to recover dues, it won't fall within the ambit of commercial courts. Or if a landlord has refused to repay the refund the security deposit, then that won't fall at the commercial court. So it's actually what our understanding of the term commercial is, but it has been specifically defined. So if it is a specific dispute pertaining to a commercial transaction, then you can approach commercial courts. Here, one important change that is made is that earlier only the dues or the damages claimed had to be above 1 crore. This was the case up to 2018. However, in 2018, a change was made, and the claims now have to be above 3 lakhs. So this is a very significant change that has been made recently, where even if you have a claim of 5 lakhs, now you can approach the commercial court, which avenue was earlier not available to you, so to creditors. So that is a very important change that has happened. Another very important change is that now there is this concept of mandatory pre-institutional mediation. This is given under section 12A of the Commercial Courts Act. So now, even before you approach the commercial court, first you have to go to mediation. Now, since I practice in Pune, I can tell you that we have the DLSA here, District Legal Services Authority. So you go to them, you file the mediation application. They will basically, send a notice to the other side, tell them that just if you want, you can convey your consent to participate in the mediation proceedings. And if the other side is to, convey their consent, then a mediator is appointed, and it is seen as to, whether it is possible to settle this dispute in mediation. If it is settled in the settlement happens, then you just sign like a settlement agreement, and that is the end of the matter, because it will be binding on both parties. And in case there is no mediation that happens, then you get a non-starter report, and with that non-starter report has to be filed when you approach the court with the claim. So this is again a very important point, because usually debt recovery matters, it is usually a straightforward matter. There is, or even if there is a dispute, it's not going to be a very big dispute. So ideally, if it can be settled through mediation and conciliation, that would be in the best interest of both the creditor and the debtor. So this is a good forum to explore that, even before approaching the courts, you undergo the process of mediation. And another point is that, see, suppose now you file the case. As I said earlier, that before the civil courts, that period of 90 days is there, but it can be waived off or condoned. Any additional delay beyond 90 days can be condoned by the courts. But here, one very good thing that is done is that the Commercial Courts Act specifically says that the written statement, that is the reply to be filed by the debtor, has to be filed within 120 days. And in a recent decision of the Supreme Court, in the case of SCG contracts, it has been stated that this provision is mandatory. So suppose within 120 days, a debtor is not able to file his reply to the plaint or suit, then he is barred from filing his reply. So his stand in a way will not be taken into account. So even if he's disputing something, it will be very difficult for him later on to prove that, no, this is a disputed matter and all that. So this is, again, these are three very important things which we should keep in mind: the mediation aspect and the 120 days aspect. And one last important point when it comes to commercial courts is that there is also the concept of a summary judgment procedure. So once the suit has been filed, so Order 37 will not apply, but there is a judgment summary suit procedure also prescribed in Order 13A, where it is basically stated that, once it can be shown that the debtor has no triable case, the commercial court can directly pass the judgment. So I'm not getting into detail because, like I said, we have other forums to also cover. Just keep this in mind that, instead of just telling the client, okay, let's go to a civil court, also consider exploring this option of commercial courts. Now coming to MSME. Now MSME is a forum which has existed, which came into existence in 2006 when the micro small MSME Act, we can say, was introduced in 2006. Now, MSME Facilitation Council is set up. Now, why this has gained prominence in recent years is that earlier these MSME for enterprises, like the micro small enterprises, were required to file a document known as an entrepreneur's memorandum. And with that, they got a registration. And if they had that registration, only then could they approach the MSME, this MSEFC, that is the council, right? Facilitation Council. Now, it has the government in 2016 and thereafter 18 has introduced a registration known as Udyog Aadhaar, and recently it is known as Udyam registration. So it is more like a self-declaration, and it has now become very easy to, get registered under the Act, MSME Act. Now, accordingly, because this registration is easy, it is now that you will have many cases where MSMEs would prefer to approach the council rather than go to civil court for recovery of their debt. Now, coming to the salient features, this purpose of this forum is only for the recovery of debts in a time-bound manner. So, suppose, like I said, that there is a buyer of goods. The goods were not as per what he wanted, not as per specification. He suffered damages, but this buyer, even if he may be a micro or small enterprise, cannot approach MSME. MSME is for the very specific purpose of recovery of debt. So it is actually a very dedicated forum for recovery of debt and may be considered if the client has registration for the same. Only we have to keep in mind that at the threshold, only there may be certain jurisdictional issues. It may not be that just because you have a micro or small enterprise registration and you hold a Udyam registration, you are able to approach the council. There are only specific types of enterprises which are allowed to approach the council. So these are just manufacturing enterprises and service enterprises. So we have seen cases where traders have also received a registration, but the council members will say that no, you are not a manufacturing entity nor a service provider, you are just a trader, so you are not allowed to approach us, you may go to civil court. So these few threshold limitations have to be taken into account. One important point is there is no filing fees. So many times it may happen. So one thing actually I got to mention, when it comes to commercial courts, mediation fees can go up to 30,000, 40,000. So that mediation fee can be a little bit daunting for some credits, some clients. They may feel that why should I give so much fees just to recover what is actually rightfully mine. So here, with respect to the aspect of fees, there is no filing fees. Another important point is, like I said, that in civil suits, if the interest amount is not specifically mentioned in the agreement, it is up to the discretion of the court. A very important feature of MSME Act is that it says that interest, if there is a delay in payment, interest will have to be paid. It will be paid by the buyer or like debtor on a compounded basis. right? So this becomes a statutory interest. So even if the client has in the agreement not decided the interest, it will still be payable by the buyer or the debtor compulsorily under this act. So purpose of this act is that, to ensure that there is sufficient credit with the MSMEs also. Always, they should not be impaired, or functioning should not be impaired just because someone has failed to, make the payment of dues on time. You will have large corporations or, even public companies who will just ignore. For them, MSME is a small entity. They also know that, MSMEs, if they file a civil suit, not much is going to be done. So from that perspective, this is a good forum to explore. However, also keep in mind that, like I said, that, in 2015-16, the registrations opened up. So keep in mind that it is an evolving law. So suppose there are recent decisions which have come up, wherein, it has been said that if you don't have a registration, you cannot approach MSME. Up till now, there were a few high court decisions which said that no, registration is not mandatory. There are a certain criteria which you have to fulfill when it comes to manufacturing, with respect to what your turnover is, what your net worth is. And if you're fulfilling those criteria, registration is just a paper and not required. But recently in 2021, the Supreme Court said that no, without registration, you cannot approach the MSME. Then another point is, works contract. Now, works contract is something like constructing a building. One client we have where, they're constructing a railway line. So whether railway line, can we say it is supply of goods or supply of services, or it is a completely different contract? So all these things, it is still evolving law. Because more people have started approaching, all these questions have started coming up, and accordingly you will have to be very mindful of any judicial changes that will happen, and they are bound to happen in this case. So all these things will have to be kept in mind when approaching the MSME council. And now I'll just quickly take you to the procedure. That basically, first you will be asked to file. So it's a very simple procedure. You have the MSME Samadhan portal where you just file the invoices and the purchase orders first. Notice goes to the debtor telling him that either make the payment or settle. If the debtor makes the payment, well and good, the matter ends there. You just write a letter saying that we have received the payment. If the debtor doesn't pay his dues, then you file a petition in a hard copy before the MSME, and then the debtor will reply. Again, important point is that this is a very different sort of a council. It's not a tribunal. So first, it is more like a conciliation proceedings forum. So first, council will ask you whether you would like to go for conciliation, see if you can settle the matter. I'm sure, like, if you waive off the interest, something can be done. So conciliation is what is aimed at. So similar to the Commercial Courts Act, again conciliation is aimed for, which is and this conciliation is mandatory. Like I said, in civil courts there is no conciliation which is mandatory. It may be referred by the court later, but conciliation per se will not be mandatory. But here conciliation is mandatory, and like I said, if the matter gets settled in conciliation proceedings, nothing like it. If conciliation does not happen, then the matter goes into, then the nature of the proceeding before the MS council becomes an arbitration proceeding. So all the procedure, like to the extent applicable, the provisions of the Arbitration and Conciliation Act 1996 will apply. And thereafter, again, similar to arbitration proceedings, the statements will be filed, the documents will be filed, the arguments will be made, and based on that, the arbitral award will be passed. Now, arbitral award, again, it will be, if you want to go appeal against that arbitral award, then an amount. So basically, if the debtor is asked to pay, settle the dues, and he wants to challenge the same, then an amount of 75% needs to be deposited by the debtor before he can, challenge the arbitral award. So from that perspective also, they have put the onus on the debtor and tried to ensure that MSME, micro small enterprises, do not suffer. So this is, again, I would say, a bit of an upcoming field. And although, you will have lawyers as well as certain accountants or non-lawyers also appearing, but this is a good forum to explore. Now, quickly take you through, as we know, the next forum will be NCLT. So we have the Insolvency and Bankruptcy Code that was brought in 2016. Now, as I said, if we see the first line, the purpose of this forum is not actually debt recovery. The purpose of insolvency and bankruptcy code is to ensure that, if a particular entity is unable to pay its debts, probably it is not in a very great financial situation, and how best to ensure that this debtor, by maybe changing its management, by the creditors, the lenders taking a bit of a discount or haircut on their loans, how can we best ensure that the debtor continues to be a growing concern? So basically, the idea is to ensure. So suppose, as we see that, the Anil Ambani the Reliance group belonging to Anil Ambani, it is currently not doing very well. So it has a lot of debt. Now, all these concerns may be sent to the IBC, so that IBC will see that, is there someone who wants to purchase this company and turn it around. So the idea, if you go to the IBC, go through IBC to the NCLT saying that, this amount is due to me and I have to be paid this amount, that is not going to happen. And that is not the nature of the proceedings as well. So sometimes, clients may approach you saying that, under IBC, why don't we recover? But although practically it may happen that you do recover the amount, the purpose of it is not the same. And if you mention this to the NCLT may take a very adverse view of the matter and may even wish to, reject your petition on the basis that you have not come to ensure the debtor continues to be a growing concern. You just want to recover your debt. Now, the nature of the proceedings is with summary proceedings. I will come to that. Again, recently, so earlier the threshold limit was 1 lakh. For approaching the NCLT through IBC. Now, in March 2020, it was raised to 1 crore. So again, MSMEs and all, they cannot approach IBC anymore, NCLT through IBC anymore. But like I said, the MSME Council and the Facilitation Council and the commercial courts are still open to them. And a distinction is made between a financial creditor and an operational creditor. A financial creditor, to tell you simply, is majorly the banks who have given loans, or the financial institutions like NBFCs which have given loans. And then we also have operational creditors. Basically, these are the creditors, the debts which have arisen in the course of trading transactions, right? Now here, like I said, it is a summary proceeding. So it is very important that the outstanding dues have not been disputed by the debtor. Now suppose, again coming back to the basic point that I supplied goods, they were not up to the mark, the debtor is disputing them. So if that is the case, then the NCLT is not going to admit your petition. They are going to say that no, this is a disputed debt. So probably the debtor is in a position to pay off your debt, but he is not paying this for other reasons, right? So it is not as if he's unable to pay, he's just not willing to pay because you did not honor the agreement or contract properly. So from that perspective, outstanding dues should not be disputed. So this is something to be kept in mind, because I said it like that, you always ensure, like, and the first slide that I was talking about, just check whether the dues are disputed or not. So this is where it becomes important, because the NCLT is not going to have the time to check whether, the claim is correct or not. And now, like I said, I'll just quickly take you through the procedure. That first of all, if you are an operational creditor, then you have to issue a notice. So here, the concept of mandatory statutory notice comes in. So you have to issue a notice. This notice requirement is not there for the financial creditor. If the debtor disputes your notice, like when it comes to operational creditor, then again it is a bit of an issue, and you may take a call whether to approach NCLT or not. Then you file a petition before NCLT, and if the petition the NCLT feels that okay, it seems like a straightforward transaction, not disputed by the debtor, then the NCLT may accept or reject. So if it feels it's disputed, it's going to reject the petition. And if it feels it's a proper, straightforward transaction, clean transaction, it will accept the petition. And now the thing is, so suppose once it has accepted the petition, it is not going to pass an order saying that, this debtor should now pay the operational creditor. This is not within the purview of IBC. It is actually going to refer the matter to what is known as a resolution process. And in the resolution process, what happens is that a resolution professional is appointed. So the management of the company goes away. A resolution professional is appointed to manage the company. So this will be a third party. Usually it's a CA or a management person. And basically he will collect all the claims of the creditors. So when this aspect comes in, that is when, if your client is a creditor and the matter has gone into CIRP, that is insolvency resolution proceedings, then at that time you have to tell the resolution professional that okay, this is the amount that is due to me from the company, that the debtor company. Then basically, once the claims are collated, a committee of creditors is set up. Now here it is important to remember that this committee of creditors only consists of financial creditors. That is the banks only, banks or financial institutions. So if your client is an operational creditor, he is not going to have not going to be a part of the committee of creditors, or even if he has some representation, he will not have any voting rights on the same. So once this committee is set up and all the claims or outstanding dues are collated, then resolution bids are invited from third parties to submit a resolution plan. And once this resolution plan is submitted by a third party, the committee of creditors, which is just the banks and financial institutions, they will decide whether this plan is good enough or no. The resolution plan will generally provide, in that if suppose 100 crores are due to the banks, then I will pay maybe 20 crores or 50 crores. So if the banks are, allow me to pay you 50 and let me take over the management of the company, and that new person will also become the owner of the company. So in such a case, it is now completely up to discretion of the banks as to how much of a haircut to take. Even if you are one bank, it will generally be 3-4 banks in case of a company. So all those together have to decide how much of a haircut to take, and also whether resolution plan provides for something for the operational debtors or no. All these things have to will be taken into account, and accordingly, if it is accepted and approved by the NCLT, then the creditors will accordingly take a haircut, and perhaps nothing may go to the operational creditors. And if it is not approved if that resolution plan, which is submitted by the new buyer, is not approved by NCLT or not approved by COC, then the company goes into liquidation. And there again, you have a sort of a waterfall mechanism that first dues of employees will be cleared. Then if you have any secured creditors, those dues will be cleared. So in such a case, the chances of recovery for operational creditors is not very high, is what is seen practically. So again, you should always keep in mind, suppose it's a banking entity that is your client, then again NCLT may be a good enough option. But if it is an operational creditor, the chances of recovery are not going to be high. So only case where you may get an operational creditor may get relief from through this procedure is that before the petition is admitted by NCLT and the proceeding goes into resolution process, that the debtor says that okay, I'll pay you, you withdraw your petition. So this is the only way in which the operational creditor can receive that money. So it is not really a recovery forum, but it is important to keep in mind that practically you may be able to recover your money. So this is something you should keep in mind, that again, see, all these are new forums. Our IBC code came in 2016. Then Commercial Courts Act 2015. MSME, like I said, the registration was made easier in 2016. So now there will be a shift away from maybe arbitrations or approaching civil courts, and these are the new forums which may come up. So it will be good to know about these forums. And another important forum will be arbitration, right? So as we know, these arbitration proceedings are governed by provisions of the Arbitration and Conciliation Act 1996. So suppose in the agreement there is a specific clause which says that in case there is a delay in payment and a dispute arises, then matter will be referred to for arbitration. So this arbitration clause in the agreement is very important, and without it, matter cannot go to arbitration. So, and once a matter is sent to arbitration, then the jurisdiction of the civil courts is barred. So once you have arbitration, then you cannot approach the civil courts once there is an arbitration clause in your agreement. To quickly tell you, the important thing about arbitration is that it deals with the concept of party autonomy. So the parties can decide on the procedure, whether they want oral arguments or only written arguments are fine, how many arbitrators to appoint, all those things. So completely what procedure to follow. So Evidence Act and all will not apply in an arbitration proceeding. So all these things just make the proceedings a little faster. And another point is that even the arbitral award that will be passed. Now, suppose in civil court there is an order passed and the debtor feels that it is a wrong order, he will go and appeal, right? Same will be the case in commercial courts. So, and he will challenge the order on the merits. Now, in case of arbitral award, to ensure that there is a finality to the award on merits of the matter, it cannot be challenged, and it can be challenged on very specific grounds, which are given in Section 34 of the Arbitration Conciliation Act, which is if there's like a patent error and all those things. So this or jurisdictional error. So on these points, like the arbitral tribunal just did not have the jurisdiction to decide the issue. So, but on merits, there will be a finality to the award unless it is overturned on the basis of certain jurisdictional issues or apparent errors on record. So, from that perspective, arbitration may be a good enough idea, but again, it will be expensive because fees and all will depend on the arbitrator, right? So, like I said, mentioned earlier, this proceedings will be similar to our regular proceedings. Parties can decide procedure, so no CPC, Evidence Act provisions will not apply. Even the place of arbitration can be decided. So I had recently seen an agreement where it was a housing finance company. The entire transaction happened in Mumbai, but because the headquarters of that housing finance company was in Chennai, they said that the arbitration, like if there's a delay in payment, we will settle this through arbitration, and the place of arbitration will be Chennai. So for my client who was placed in Mumbai, he had already agreed to such an arbitration, and he was in a bit of a suit. So there again, you will always have to be mindful of whether arbitration clauses exist or no, and what do they provide. Again, like the language can be decided, language of arbitration can be decided by the party. So there is complete autonomy. And as I said, there'll be a state with respect to the procedure. First, a statement of claim with documents will be filed by the creditor. There will be a statement of defense. Now, one important and good thing is that in 2018, there were certain significant amendments that were made in Arbitration Act, and time limits have been given, which says that these statements of claim and defense are to be filed within 6 months from date of appointment of arbitrator. Then the arbitrator should try for an expeditious hearing. And even Section 29A of the Arbitration Act provides that there is a time limit for passing award, which is 12 months from the date of completion of hearings, and this can be extended by I think 6 months if the parties agree. So again, even the Act is providing for finishing of the proceedings in a time-bound manner. Now, as you can see, the whole issue is that while debt recovery matters may be straightforward, it is the delay in the courts that may be causing the issue. So these even and all, like I said, again, this is 2018 amendment. So we can see that even the government is trying to push debtors to ensure that these debt recovery matters are getting done on time and in an expeditious manner. I'll quickly just tell you about debt recovery tribunal. So salient features here are that that there's a threshold limit of 20 lakhs, and only banks and financial institutions can apply. Again, the stages are similar. That you file the application, summons is issued to the defendant. There is a filing of written statement by the defendant, and counterclaim can also be filed. And then there is a stage of admission and denial of the documents, and evidence is usually led by way of affidavit. So as I said that in civil courts, you have the concept of chief and cross-examination. Usually it is not followed in the DRT. Now, the reason for talking about DRT is that one interesting point that, like I said, in maybe MSME, arbitration, or even civil courts, suppose an order or an award is passed saying that, okay, the debtor owes maybe 1 crore rupees to the creditor, he should pay. Now, if the debtor still chooses to not pay, then again, you have to go to civil court for the execution proceedings. Now, here, what is interesting is that the Debt Recovery Tribunal itself provides a mechanism for recovery, right? So here the civil court is not required to be approached. Once a final order is passed and a recovery certificate is passed, there is an independent mechanism. You have a recovery officer who will act on the basis of the recovery certificate to enforce that order. And basically, this again, like I said, that you don't have to go through the courts. So again, it will be a faster mechanism. However, like I said, keep in mind that this debt recovery tribunal will mostly work in case of clients where banks or financial institutions are the creditors. However, you may also be approached by clients who are the debtors, who may approach, who against whom cases have been filed before the DRT. And in such a case, although maybe on merits you may not have a very strong case, but usually it is seen that procedurally, if there are some issues on those matters, some relief may be received by the debtor. Like even computation of interest may be a point on which there may be some dispute and some relief would be received. So this is the Debt Recovery Tribunal. Lastly, I'll just quickly in 2 minutes sum this up. So even cooperative courts have been set up under the Maharashtra Cooperative Societies Act. It is limited only to cooperative societies, so cooperative banks or cooperative housing societies can approach. You have the cooperative courts which are set up under Section 91. Although they are called courts, they are actually tribunals. So again, Evidence Act and CPC may not necessarily apply. And another important point is Section 101, where instead of approaching the tribunal or a court, you approach the registrar. And these are very summary sort of proceedings. Basically, based on principles of natural justice, the registrar will hear the parties and he will pass an order saying that, okay, this specific amount is due from the debtor to the buyer. So this is something which I actually was not very aware of and got to know about recently. So I thought at least I will, mention it here that this is also a recovery forum. And quickly, I mean, though not necessarily a recovery forum, you may also consider, so very specifically in check bouncing cases, if it has happened that there was an amount due, check is given, but it was not honored by the bank on account of the fact that there were not sufficient funds available with the debtor and the check was dishonored or bounced, as we say in common parlance. Then in such a case also you can approach, you can file a suit or a complaint under Section 138 of the Negotiable Instruments Act and basically if the payment is not made by the debtor, then it will invite certain criminal implications. So though very specific to check bouncing cases, it is usually seen that such trade debts or even sometimes financial debts, like when in case of a loan, the payment is not done on time and a check bounces. So that is also something that could be considered. But I've not gone too much into detail. So now to sum up, like I said, that when you are advising a client, now this is more when a creditor is approaching you, consider what are the things you should at least keep in mind. Now, first is jurisdiction. Like I said, that suppose there is an agreement, you tell him, okay, let's go to, let's approach the civil court, or, there's this new forum called commercial courts, a relatively new forum called commercial courts, let's approach a commercial court. But if you later on find out that there is actually an arbitration clause, then as I said, the arbitration clause takes away the jurisdiction of the civil courts. So in such a case, be very mindful of all these factors that, is there an arbitration clause? Then another important point that has come up is that suppose now, like I mentioned that before MSME, the proceedings are arbitration proceedings. Now, suppose there is an arbitration clause in your agreement, but the supplier is a micro or small enterprise and it chooses, ignoring that arbitration clause, it goes and approaches the micro small facilitation council. Then can you in such a case say that no, arbitration clause has taken away the jurisdiction of the MSME? So this was an issue that was raised in recent times and the courts have held that no, under MSME, it is a statutory form of arbitration. So it is mandatory and in any case, it will in the end be an arbitration only. Even if you go under your arbitration clause or you come to MSME, at the end of the day, it is a form of arbitration. And if instead of invoking the arbitration clause, that party has chosen to come to MSME, then the proceedings under MSME will continue. So these things you need to keep in mind that whether the court even has the jurisdiction in the first place. Secondly, like I said, type of creditor. So when it comes to MSME, do that check as to whether that party is a micro or small enterprise, whether it is manufacturing service entity or a trading entity. So all those things also should be kept in mind before deciding the forum. Nature of the dispute. Now, nature of the dispute is important when it comes to Commercial Courts Act, even MSME Act, right? Because MSME Act is meant for debt recovery. So if you have to claim damages, maybe MSME is not the forum for you. And if it's not a commercial transaction, then commercial courts are not the right forum for you. Like I said, the recovery of security deposit, you cannot approach a commercial court. Another important thing that we have seen is the aspect of the forum fees. Because even when, like I said, in Commercial Courts Act, first you have to go to mediation. There again, the fees may be a little high. So if it's a small entity, it may feel that no, I cannot afford this fees for mediation, because what happens if the other side doesn't agree, then I still end up paying that mediation fee. So this again, practically it is seen that fees can be an issue. So in such a case, MSME can be considered, or IBC again, the filing fees will be 10,000. Right. So these aspects you have to consider. Then interest, as I've already mentioned, that whether there is an interest provision in the contract. Suppose there is no specific interest provision, then should MSME be approaching because it provides for statutory interest. So, like I said, that interest again may be an important determining factor in which forum to approach. Even objections of the buyer, like I said, that if it is disputed IBC and NCLT may, like approaching NCLT through IBC may not be the right forum for you. Even in case of MSEFC, like I said, that they are not actually judges; they are more like government functionaries. So there, if you feel that there are objections raised by the borrower, and it is a bit of a technical issue. Like recently, someone had come to me that said that the whole issue pertains, like the dispute pertains to whether the machinery is technically as per what the buyer wanted, like who is now the debtor, and according to him, it is not as per the specifications. So there is no point, so which is why we want to approach the MSME. So there again, you may take a call that is it something that is so difficult that it may be beyond the understanding of maybe even the lawyers or the judges, and then take that call that which will be the right forum to approach, or would arbitration have been the right forum to approach? Because in case of arbitration, it is not necessary that that person has to be a legal person. It can be someone who's a technical expert in that field. So even from that perspective, you can decide based on the nature of the dispute or the objections of the borrower. Again, what sort of relief do you want? If you want to do like recovery of amount, then IBC, like I said, IBC is not the right recovery forum for you. If you want ensure interest, approach MSME. Damages, again, you cannot claim damages when you go to IBC, the NCLT through IBC, nor can you claim damages when you approach the MSME, right? So these things have to be kept in mind. These are a few important factors that need to be kept in mind. Appeal provisions is again very important. Like I said, in case of arbitration, you cannot file an appeal on merits, right? So that could be an important factor, because in civil court, you may challenge it on merits, and the appellate proceedings, again, the matter is going to get prolonged. So arbitration could be considered. Same thing with MSME, because MSME order is again effectively an arbitral order. So consider that. When it comes to DRAT, which is, if someone wants to challenge the DRT order, then if it is a debtor, he has to make 50% of the amount deposit before the DRAT in order to file his petition. So these again are all factors you need to keep in mind. Limitation period extension I have already spoken about, and the enforcement mechanism. Like I said, in DRT you have a ready enforcement mechanism. For other forums like arbitration, MSME, or even Commercial Courts Act, you have to go back to the court for execution in case the order is not followed. And one important point you will always see is that generally in other matters, if something goes wrong, the party will always be willing to file a suit, right? But in commercial courts, in these commercial matters or debt recovery matters, what usually happens is that it is a continuing relationship. So it's a case where even if the person, like even if the trade debtor is not paying you, even then the creditor is like, let it be, let's give him some more time. In any case, I have a continuing relationship. Even if I don't get this XYZ amount, he's going to keep buying supplies from me. So that is also a commercial angle. So whether it may antagonize the debtor, that is also something you may have to keep in mind. And this is specifically true for trading transactions, and particularly more when it comes to smaller enterprises, because they also have some sort of a personal relationship with each other. So these are various things you should consider. But again, like I said, these are new forums that are coming up. Civil court is not the only forum. So definitely it will be good to consider various forums. And when you are considering these various forums, also consider these various factors. And based on that, you can give the best advice and best possible legal service and professional service to your clients. So with that, I come to the end of my presentation. Thank you. Thank you.
While one can argue that with company B's bankruptcy, there is no liability to pay creditors. The contract for B was through the holding company A. What's the recourse to recover the dues, particularly when both A and B are located outside India? Any time limit to file?
So in case of any recovery, again, like I said, that limitation period is 3 years for recovery of dues. Even if I think contract is through A, but again, the recovery aspect has to be with B, right? Because it is company B which is owing dues, which has outstanding dues. So there again, it will be difficult to proceed against A, because A may just be said to be like doing the licensing work perhaps. So it will be a little, and suppose it is a company which has gone through the insolvency process, then there is the concept of moratorium, and basically once if a resolution plan has been accepted, then the dues of the company get cleared. So in that case, it may be a little difficult to approach the IBC or any civil forum, because once the company has been through the IBC process and through the NCLT, like I said, that the resolution plan is given, and the committee of creditors is going to accept that plan. Now, suppose the committee of creditors says that, okay, operational creditors are not going to get anything, or going to get like 10% of their dues will be paid to operational creditors. Then that 10% has come to you, or if nothing has come to you, then even then, as an operation creditor, it is a bit of a disadvantage. And accordingly, I feel that it will be difficult to have any legal recourse, because that is the purpose of IBC. That you start with a clean slate. Basically, that idea is that the company which has undergone resolution process starts with a clean slate. Now, unless A has been a guarantor, right? So unless A has been a guarantor, it will be difficult. But this is also actually one aspect that I had mentioned. That if A has said that I will guarantee, then recently the NCLT and even Supreme Court has held that this sort of guarantee can also be proceeded against under the IBC mechanism. So maybe if it is a guarantee given by company A, that could be considered.
How is SURFACE different from DRT, and what is the process of SURFACE Act?
Right. So SURFACE Act actually I did not deal with, because we were talking about fora. So just to give an idea, SURFACE Act is where it is meant to deal with securitized assets, right? So suppose you have a bank is giving you a loan, and home loan, and then it says that the house will be kept as a security. So the whole purpose of SURFACE Act is to ensure that you don't have to approach a court to get redressal of your problem of outstanding dues. Basically, under the SURFACE Act, effectively what can be done is that the bank can give a notice to the debtor saying that this amount is due from you, and if you're not able to pay the same, then we will attach the asset. So it is in a way of ensuring that the courts do not have to be approached, but SURFACE can apply only in cases where you have securitized assets, which may not always be the case. Or in case of trade debts, you will never have a security. So that is, this is again a very broad aspect, but this is the proceeding under SURFACE.
How does the award given by MSEFC Council get executed?
No, so like I said, that award is basically an arbitral award. So the execution for execution of the same, you will have to come to civil courts. So in civil courts, you have Order 21 of CPC, which provides for execution. So that again becomes a process, but that is how it will happen. So in case the debtor is not, honoring the order, then you will have to go through that. So execution becomes a different process. On the basis of the order, it won't be possible to attach any assets, basically.
What will be the remedy in case of a false dispute created by the corporate debtor?
Basically, what the court may consider is that for frivolous, if the court debtor, so like I said, that suppose it is a frivolous dispute, then ideally go through the summary mechanism, right, where he doesn't have the chance to defend himself. So if you go through the summary process under Order 37 of CPC, then anyway at the very threshold, the court will determine that it is anyway a frivolous and sham case that the debtor has raised. And accordingly, we should not give him the right to defend. And probably in civil court, if it's an absolutely frivolous case, I think maybe damages could be considered by the court. But usually it will be the principal amount and interest. So like I said, the whole purpose of these summary proceedings, mediation proceedings, the whole purpose is to ensure fast track. So that because the whole problem was that debtors, more than debtors not being in a financial position to pay, the problem was usually that they were unwilling to pay. They were willful defaulters. So from that perspective, now we have. So if you consider it as 7, that is why you now have 7 different forums for debt recovery instead of the civil courts.
Okay, so the next question is, what suit can be filed simultaneously along with a check bounce case?
So basically, recovery suit can be filed because check bounce is very specific to the point of check. Basically, because the check bounced, which is why you filed a complaint under 138. But it should be possible to file a recovery suit as well, because suppose over there, the person says that, okay, I had issued stop payment instructions because according to me I am not liable to pay. So suppose in a check bouncing case, the debtor is disputing the transaction and he says that it is not just a case of insufficient funds, but I am disputing the transaction. Then in such a case, it will just reject the complaint, right? So simultaneously you can file the matter before the civil court, because it's not in every case that a debt recovery matter that a check bounce will arise. So check bounce in that case will be a secondary or alternative process, parallel proceeding. But ideally, you should always go for a debt recovery process.
One of our relatives took a loan of 25 lakhs from the bank for business purposes. He is unable to repay the loan. He just paid 8 lakhs and 8 lakh subsidy. Now he received a notice from DRT. Sir, what procedure do we have to know? He is ready to repay by selling business property. Now it's 50 lakhs including interest, because he doesn't have any other source to repay the loan.
Right. No, so basically that is the thing that, mostly under SARFAESI also probably the bank would have taken some security. So like I said that, summons has been received by you. So it would be better to perhaps, file your written statement also, see whether the claim made by the bank is correct or not. Suppose the interest computation and all is not correct, then that could be disputed. And thereafter, payment will best to make the payment, because finally it is a debt due to the bank and it has shown its intention by approaching the DRT. So probably negotiations and settlement, probably that stage is gone. We've gone past that stage, and probably it will be best to repay the debt.
For landlord and tenants, any recovery has to be done through the small causes court.
No, so I understand the point. Basically, what happens is that, if it is a case of recovery of rent, so if you see the language of the small causes, like in Pune, it is provincial small causes court. So there, basically, any disputes that arise with respect to the rent or will go to small causes court. If it is a case of eviction, it may go to the Maharera, if I'm not wrong. But if it is a case of recovery of security deposit, then security deposit specifically, and there are case laws also to this effect, that security deposit does not fall within the definition of rent, which is why for a recovery of security deposit, you will have to go to civil court. And this is something actually we've also done, because in the end, what has happened is that the license agreement has been terminated, right? So we are no longer, it is not a case of recovery of rent that the landlord wants. It is the tenant who wants his security deposit back, which is why the ideal forum would be the civil court. I understand that why you would feel it is small causes, but like I said, it's mainly to do with the rent aspect that you would go to small causes. So, which is why civil court so security deposit specifically, civil court would be the forum.
So, in continuation to check bounce case query, which was raised initially, whether summary suit along with cheating case can also be filed simultaneously?
Yes, like I said, that summary suit should be ideally be filed if it's an open and shut case, and in fact, you can use the check documentation to prove that actually, he's literally acknowledging that he has to pay me the money. Otherwise, why would I have issued a check in the first place? So, in that sense, that check bounce will also help to strengthen your case in the summary suit to show that he has made the payment. So, he tried to make the payment. He has shown his intention of or acknowledged my outstanding dues, which is why he issued the check. So, in that case, the check would only help to strengthen your case in summary suit proceedings.
When the housing loan monthly EMI not paid for 3 months continuously, can the bank stick notice on the door? Can it be considered as defaming the defaulter? Can he claim compensation?
I think it may be difficult because under SARFAESI Act, SARFAESI Act, in a way, that right of attachment is given. And another point is that, usually, one or two agreements that I have seen in respect of housing loan, it says that EMI is not paid on time. Then the agreement, like the loan agreement itself, stands cancelled and the whole amount becomes repayable immediately. So from that perspective, it is the banks which are trying to basically to ensure that their recovery, because for them also they have to ensure recovery, right? Otherwise, our whole banking system will fail. So from that perspective, I think probably it is not incorrect procedure to perhaps put a note. I'm not very sure about this. I will get back to you on this. I can do that.